India Legal presents Courts Roundup.
Hello, I'm Vijay and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. And before we begin, here's the headlines. Hearing a case on pollution, the Supreme Court directs Centre to ensure smog-free Delhi. Centre informs Apex Court that panel to monitor stubble burning has started to function. In a case of a breach of privilege motion, Supreme Court has summoned Maharashtra Assembly Secretary for contempt and intimidating. Arnab Goswami says it amounts to interference in justice dispensation. Supreme Court gives ultimatum to the builders in the Maradu flat demolition case to either propose a fresh plan to pay dues or face sale of all attached properties. After banning sale and bursting of firecrackers in Diwali, Calcutta High Court bans firecrackers in Kali Puja as well.
India Legal presents Courts Roundup.
During a hearing on pollution, Centre informed the Supreme Court that panel to monitor stubble burning has begun work. The Supreme Court asked the central government to ensure that there is no smog in Delhi NCR. Senior advocate Vikas Singh, appearing for petitioners, said the pollution had worsened in Delhi, to which court said that let government take steps to curb pollution.
The central government should take steps to ensure that Delhi National Capital Region (NCR) does not grapple with smog in the coming days. The Supreme Court said on Friday, observing that courts have limitations in dealing with such issues. A three-judge bench headed by Chief Justice of India S.A. Bobde asked Solicitor General Tushar Mehta to ensure that the national capital is not impacted by smog and bad air quality, while calling for grading actions offences that contribute to decline in air quality index AQI. Solicitor General Mehta informed the top court that a body known as Commission for Air Quality Management for NCR and Adjoining Areas Commission has been set up by the central government and will start functioning from 6th of November. The centre, in exercise of its power under Air Quality Management in National Capital Region and Adjoining Areas Ordinance 2020, had constituted the commission on Thursday for tackling air pollution and plummeting AQI level in the NCR. Senior advocate Vikas Singh submitted that the condition in Delhi was akin to public health emergency and that some drastic measure need to be taken. However, the CJI stated that the case will be taken up after Diwali vacation and that the court of law has limitations since executive is the body with money and resources. We have certain limitations and we are not abdicating our responsibility. Let centre take steps, the CJI said. Though Singh raised issue with regard to the composition of the commission and how no members from the health ministry was part of the commission, the court stated that those issues will be examined after the Diwali vacation. The problem of stubble burning and the consequent air pollution caused in Delhi NCR was highlighted in a petition filed by Aditya Dubey. Among other things, the petitioner had recommended setting up of a monitoring committee and had suggested that retired Supreme Court Judge Justice Madan Lokar should head of the committee. The Supreme Court had agreed to the same and appointed Justice Lokar as one-man committee to monitor and prevent instances of stubble burning in the states of Punjab, Haryana and Uttar Pradesh. This order was passed despite strong resistance from Solicitor General Mehta. Bureau Report.
And the Supreme Court has summoned Maharashtra Assembly Secretary for contempt, intimidating Arnab Goswami. The Secretary has been asked to remain personally present for the next hearing and to explain why contempt of court action should not be initiated against him.
The Supreme Court on Friday summoned Maharashtra Assembly Secretary for allegedly intimidating Republic TV editor Arnab Goswami, which the court observed was done with the object of deterring Goswami from moving the Supreme Court. A bench headed by Chief Justice of India S.A. Bobde took strong exception to a letter written by the Secretary to Goswami on 13th October, in which Goswami was allegedly berated for producing before the Supreme Court the minutes of proceeding sent to him by the Speaker and Privileges Committee of the Maharashtra Legislative Assembly in relation to a breach of privilege motion. CJI S.A. Bobde said that such attempt to prevent citizens from exercising their right under Article 32 would amount to serious interference with the administration of justice. The Secretary has been asked to be personally present and explain why contempt of court action should not be initiated against him for the October 13th letter. The court also observed that the letter was in the teeth of Article 32 and amounted to a threat to prevent Goswami from moving the Supreme Court. The Secretary in his letter to Goswami had stated that though the Republic TV editor was informed that the proceedings relating to the breach of privilege motion by Maharashtra Assembly against Goswami were confidential, he had presented the same before Supreme Court. The intention of the officer seems to be to intimidate the petitioner because he moved the Supreme Court and to threaten him with penalty for doing so. The officer would have been well advised that the right to approach this court under Article 32 is itself a fundamental right, the court said. Goswami has approached the court challenging the September 16 privilege motion sent to him by the Maharashtra Assembly for his criticism of the government in action in the Sushant Singh Rajput case. The 60-page privilege notice against Arnab Goswami was sent after a motion were moved against him by the Shiv Sena in both Assembly House in Maharashtra. A privilege motion can be moved if an individual or authority violates or disregards any of the privileges, power and immunities of the House concerned or member of the House or committee. What amounts to breach of privilege or contempt is decided by the House, which also decide the punishment. In his response to the notice, Goswami had released a statement on his channel, Republic TV, stating that he would continue to question Uddhav Thackeray and elected representatives and that he has decided to contest the notice. Bureau Report.
And the Supreme Court gave an ultimatum to the builders in the Maradu flat demolition case to either propose a fresh plan to pay dues calculated by the court-appointed committee or face sale of all attached properties of defaulting builders. The bench of Justices Rohinto Nariman, Krishna Murari and Anuruddha Bose noted that the court has pursued the latest report by the committee, which stated that a total of 61 crore rupees was outstanding from the builders. The top court further observed that a proposal to make payment was made before the committee by the 3 of the 4 builders, but the same was rejected. Thus, the court has now asked the builders to either submit a new proposal or face the sale of assets. Senior advocate R. Basant, appearing for one of the builders, stated that have been strong objection to committee reports and that builders were not heard. The court acquiesced to this request and appointed advocate Gaurav Agarwal as amicus. Agarwal has been asked by the court to have a discussion with the committee and file a report of the next day of hearing. The court has also extended the mandate of the committee till further orders. Further, the court also allowed all parties to file written submission within 4 weeks. In October 2019, Kerala government was directed by the Supreme Court to give 25 lakh rupees as interim compensation to Maradu flat owners after it was brought to the notice of the court and that some of the flat owners were not adequately compensated. The compensation was on amount of demolition of flats, which was ordered by the apex court on the ground that flats were constructed in violation of environmental norms. A bench of Justices Arun Mishra and S. Ravindra Bhatt had asked the builders to of the Maradu flat to deposit 20 crore rupees within 1 month with the court-appointed committee. The Supreme Court on Friday dismissed an appeal filed against a Delhi High Court interim order allowing publication of HarperCollins' book titled Gunning for the Godman, which is based on the criminal case against Asharam Bapu. A bench headed by Justice A.M. Khanvilkar dismissed the appeal filed by Sanchita Gupta, who was convicted as an aide of the self-styled godman in a case related to rape of a minor, with a liberty to approach the High Court. In September 2020, the Delhi High Court had vacated an ex parte injunction passed by the District Court, while holding that where there is a fair discussion in public domain which is based on facts and not malicious, and the same is protected under freedom to speech and expression. Before the Supreme Court, Gupta's counsel, senior advocate Devadatt Kamath, asserted that the lower court's order was set aside on flimsy ground and that the book in question attacked his client's reputation, inasmuch as it states that she was in the habit of procuring girls for Asaram. The top court observed that these objections were not recorded in the High Court's order and the petitioner should have raised these grievances before the High Court itself. And we are now joined by Advocate Divyanshi for more update on this.
In this case, Honorable Apex Court has dismissed the appeal filed against the order of Delhi High Court, in which Delhi High Court has passed an interim order allowing publication of HarperCollins' book titled Gunning for the Godman. The court has observed that these objections that applicant is raising in the Apex Court, those were not recorded in the High Court's order, and the petitioner should have raised this grievance before the High Court itself. And this dismissal of appeal will not come in the way of deciding this issue before High Court. So applicant has to move High Court itself.
The High Court of Kerala has issued notice on a public interest litigation petition which challenges the recent decision of the Government of Kerala to implement reservation for economically weaker section in government jobs and seats in educational institutions. It was on October 12 that the Pinarayi Vijayan's-led government issued the order to provide for reservation of 10% of the seats in general category for EWS category. The PIL against the government orders was filed by one Nujaim PK, who is said to be a social worker and an active politician and the Secretary of Fraternity Movement Kerala State Committee. A division bench comprising Chief Justice S. Manikumar and Justice Saji P. Chale has issued notice to the central and the state governments. The petitioner contended that the 103rd Amendment, which inserted Article 15(6) and 16(6) to provide for EWS reservation, was invalid as reservation cannot be granted on the ground of economic growth. The petition also sought a directive to the state government to refix the 10% quota for economically weaker section after conducting a proper study regarding the population of the EWS in the general category. In August, a 3-judge bench led by Chief Justice of India referred to a larger bench the petition challenging the constitutional amendment providing for EWS reservation. Can post be reserved only on the basis of economic criteria? Is 50% ceiling absolute? These are some of the substantial questions identified by the Supreme Court bench while referring the case to larger bench. And the Bombay High Court on Friday concluded the argument on a batch of public interest litigation petitions seeking guidelines on reporting on investigation and media trial. A division bench comprising Chief Justice Dipankar Datta and Justices G.S. Kulkarni reserved the judgment on 5 PILs, one filed by a group of retired police officers of Maharashtra Police, Mahesh Narayan Singh and others versus Union of India, second filed by filmmaker Nilesh Navalkar and others, third by a party person named Asim Suhas Sarode, fourth by an NGO named In Pursuit of Justice, and the fifth by Prerna Virendra Kumar Arora. On Friday, the court heard a brief rejoinder argument by senior advocate Aspi Chinoy, appearing in the PIL of ex-corps Assistant Solicitor General of India Anil Singh, senior advocate Arvind Dattar for News Broadcasting Standards Association, and senior advocate Siddharth Bhatnagar for News Broadcasters Federation. Anil Singh made submission on the point whether prejudicial media reporting at the stage of investigation can amount to contempt of court as interference with the administration of justice. For that, he referred to the Supreme Court judgment in A.K. Gopalan versus Noordin 1969, which he said was relied on by the Supreme Court in the 2012 Sahara judgment. However, the bench expressed doubts about the relevance of A.K. Gopalan case as it was passed before the enactment of Contempt of Courts Act 1971. Senior advocate Dattar said that the A.K. Gopalan case was relevant even after the 1971 Act, as it dealt with the inherent powers of contempt of courts under Article 129(215) of the Constitution. The Karnataka High Court has quashed a criminal proceeding initiated against former State Minister K.J. George and two IPS officers in a case of abetting the Deputy Superintendent of Police M.K. Ganapathy to commit suicide by hanging on July 7, 2016 in a hotel room. The matter was pending before a special MP-MLA court. A single bench of Justice John Michael Kuneya allowed the petition filed by K.J. George, former Minister of Urban Planning and Development, and IPS officer Pranab Mohante and Ashit Mohan Prasad, challenging the order of summons passed by the Special Court on August 28. The Special Court had rejected the B summary report submitted by the Central Bureau of Investigation and had taken cognizance of the alleged offence punishable under Section 306, Section 34 of IPC. Reliance was placed on the Supreme Court's verdict in Pepsi Foods Limited and another versus Special Judicial Magistrate and others, where it was held that the magistrate has to carefully scrutinize the evidence brought on record and may even himself put question to the complainant and his witnesses to elicit answer to find out the truthfulness of the allegations or otherwise, and then examine if any offence is prima facie committed by all or any of the accused. In view thereof, the bench held, since the material on record does not prima facie disclose commission of the offence by the petitioner, the action initiated against the petitioner accused number 1 to 3 being wholly illegal, perverse and amounting to abuse of process of court deserves to be quashed. Ganapathy had spoken about the harassment meted out to him by then Home Minister George and two IPS officers in an interview with a local television channel at Madikeri before taking the extreme step. And the Calcutta High Court has issued an new order regarding firecrackers to the coronavirus epidemic. This order of the court means that this time in West Bengal, there will be no firecrackers on Kali Puja. Yesterday, the court banned fireworks in West Bengal for this Diwali. The court said in its order and that selling and bursting of firecrackers in West Bengal will be prohibited this year. It is evident that there has been an endeavor on the part of the state to protect the air quality so that the respiratory problems that rises as a result of the infection are not aggravated because of the noxious fumes brought about by the use of firecrackers. Hearing two public interest litigation, a division bench of Justices Sanjeev Banerjee and Arijit Banerjee said that keeping firecrackers in view of the coronavirus outbreak could be harmful to the environment and infected patients. In such a situation, the court directed that the ban on firecrackers will also be applicable during Jagat Harti Puja, Chhat and Kartik Puja. That means if the court order is violated, legal action can be taken against the violators. On the issue raised by the Fireworks Association. The court said for the greater good, a small number of persons involved in the firecracker businesses may have to suffer losses. The overwhelming public interest cannot be compromised. The court also mentioned in its order that the guidelines for Durga Puja, such as not entering the pandals, will also apply during Kali Puja. The pandals will be covered in an area of up to 300 square meter and only 45 persons will be allowed to enter it. Before Kolkata, Delhi government appealed not to burn firecrackers on Diwali amid the growing outbreak of coronavirus. Delhi Chief Minister Arvind Kejriwal, while talking about the problem of corona and air pollution, appealed to 2 crore people of Delhi to celebrate Diwali but not firecrackers. The Uttarakhand High Court has suspended Chief Judicial Magistrate at Uttarakhand Neeraj Kumar with immediate effect while acting on a memorandum submitted by the residents of the Collectorate Colony at Uttarakhand, where Kumar resides with his family. The memo states that the judicial officer has a habit of beating his family and hurling abuses at people residing nearby while being intoxicated. It is alleged that on October 29, Kumar beat his family, hurled abuses and damaged the official vehicles of the sub-divisional magistrate Dunda and the Tehsildar Bhatwari. On the said night, it is stated that Kumar beat up his family member, came outside his house, and when his son requested him to return to home, he used rough language with his son and people nearby who tried to stop him. Kumar also allegedly attempted to drive his official vehicle while being in an inebriated condition and stopped the said vehicle in the middle of the road while honking continuously. Later on, he is said to have driven to the parking of the colony and damaged other government vehicles parked there. The High Court has found such conduct of CJM Kumar to be in violation of Uttarakhand Government Servant Conduct Rule 2002, owing to which disciplinary proceedings are contemplated against the judge. Furthermore, during the period of suspension, Kumar is entitled to get only half of his salary payable on the date of suspension as subsistence allowances along with dearness allowances. Other compensatory allowances shall be admissible subject to the condition that such expenses is actually incurred by him as the order. And that's all we have for Courts Roundup today. Thank you for tuning in.
India Legal presents Courts Roundup.